someone passed away and probate was never opened, you might assume the estate just resolves itself. In most cases, it didn't. The consequences of skipping or delaying probate tend to compound over time, and the longer it waits, the harder it gets. My name is Ryan Smith. I'm a licensed realtor and certified probate expert, and every day I work alongside families navigating probate and estate administration. I encounter situations like this regularly. Maybe a parent passed away years ago, the family stayed in the house, or they kept renting it out and no one ever went through the formal process. Or someone passed recently and the family is hoping they can simply avoid the cost and the complexity of probate. This video covers what actually happens to an estate when probate is never opened and what options exist when you're in that situation. I'm not an attorney. What I'm sharing here is educational. It's not legal advice. It's based on my personal experience. I highly recommend meeting with an attorney that specializes in probate and estate administration. If you need a recommendation for an attorney, please let me know. I'd be happy to share some great options. Okay, before we get into what happens when it's skipped, let's understand first what probate actually accomplishes. Probate is the legal process that establishes the legal authority to act on the estate's behalf. Transfers title to assets from the decedent's name to the estate and then on to the heirs. It pays the estate's debts and taxes in the proper sequence, and it creates a legal record of how assets were distributed. Without that process, most of those things simply don't happen officially. The assets may exist, the heirs may be living in the house or spending the accounts, but legally, the estate remains unresolved. So what happens when probate is never opened? Title to real property stays in the decedent's name. This is the most significant consequence for most families. If a parent passed away and probate was never opened, their name is still on the deed. So the heirs may be living in the property or receiving rent from it, but they don't legally own it. And therefore they can't sell it, they can't refinance it, they can't transfer it cleanly. Any title company handling a sale will find this issue immediately. Also, the debts don't disappear. Creditors have a defined window to file claims against an estate. If probate's never opened, that window never runs. Depending on the estate and the creditor, outstanding debts can remain attached to a property and surface as liens when a sale or transfer is eventually attempted. Tax obligations may accumulate. Estate tax returns may have been required and they were never filed. Property tax obligations continue regardless of whether probate was opened. So missed filings can generate penalties that accrue over time. The estate becomes harder to administer over time. Witnesses pass away, documents are lost, heirs multiply through marriages and births, and the chain of title becomes more complicated. So what would have been a relatively straightforward probate 5 years ago can become a significantly more complex process today. Let's go through the title problem in detail. Because real estate comes up so often in these situations, it really deserves its own segment in this video. When someone passes away, at least here in North Carolina, title to real property doesn't automatically transfer to the heirs. If there's a will, probate is required to transfer that title. If there's no will, the process is different, but it's still required. The result when neither happens is that a property is sitting in a dead person's name, sometimes for decades. When a family eventually tries to sell or transfer the property, a title search will reveal this issue, and then the sale can't close until the title is cleared. Clearing title on an estate that was never opened typically requires opening a late probate. It's sometimes called a muniment of title proceeding or similar, depending on how much time has passed and what North Carolina law allows. This is where a real estate attorney or a probate attorney can tell you exactly what process applies to your specific situation. Here where I'm in southeastern North Carolina, New Hanover, Brunswick, Pender counties, I work with these situations regularly. I can connect you with attorneys who handle late probate and estate title issues specifically. Not every estate requires formal probate. There are situations where assets transfer outside of probate legitimately. Assets with named beneficiaries, such as life insurance, retirement accounts, certain bank accounts pass directly to named beneficiaries without going through probate. If property is titled as joint tenants with right of survivorship, the surviving owner inherits automatically. Trusts, Assets held in properly funded living trusts transfer according to the trust terms without probate. Small estate procedures. North Carolina provides simplified procedures for estates below a certain threshold. So this is where a probate attorney can confirm whether your estate qualifies. A key question is always whether the specific asset in question has a mechanism to transfer outside of probate. Real estate held solely in the decedent's name almost always requires some form of probate or court proceedings to transfer that title. What to do if probate was never opened? If you're in this situation, whether it's a recent death or one from years ago, the path forward is the same. First, get a probate attorney involved. The specific process depends on how long ago the person passed, what assets are involved, whether a will exists and where it is, and what the current state of the title looks like. An attorney who handles late probate or estate title matters can assess your specific situation and tell you what process applies. In many cases, it's more manageable than families even expect it will be. However, in some cases, it's more complex. So either way, waiting does not improve this situation. If there's real estate involved, whether you're trying to sell it, transfer it, or simply clarify who owns it, I can connect you with probate attorneys who handle these situations regularly. And when the property is ready to sell, there's a no obligation assessment available at any point. Just reach out for that. So the bottom line is, skipping or delayed probate doesn't make an estate disappear. It defers the process, and generally it makes things more complicated when it eventually has to be addressed. If you're dealing with an estate where probate was never opened, regardless of how long ago the person passed, the right first step is a conversation with a probate attorney. Thanks for watching. If you'd like to walk through your situation, I offer a free consultation, no pressure, no obligation, so feel free to reach out anytime.